And again, I do appreciate your time. I appreciate your patience. And here we go. So Syntel, based in the Washington, D.C. area, has a number of different clients up in the New York State area. We actually have a sister company that does some publishing stuff out of Rochester, New York. So we stay on top of what's happening in the New York State in general, as well as the city itself. And therefore, I wanted to share what I know about the SHIELD Act and what's happening in New York State when it comes to cybersecurity and the protection of information, that type of thing. An article not too long ago, really at the end of last year, under law.com, said that there are major data breaches that have jeopardized the confidential personal, financial, and health information of millions of Americans. And this continues to make headlines. We all know that. Virtually all organizations, including government, that compile and store personal data are vulnerable, as are the contractors, vendors, and others with whom they share such data. Recently, a security breach at a medical collection agency serving hospitals and clinical, let me get someone in here, and serving hospitals and clinical laboratories, sorry, there we go, compromised confidential information of between 20 to 25 million patients. So listen, a medical collection agency compromised 20 to 25 million patients' data. That, that's going to bring about some serious fines, and that's just not good, period. This included patients at a major hospital system within New York City. A large upstate health system as well recently agreed to pay $3 million and take substantial corrective actions after personal health information of patients was improperly disclosed as a result of a loss of an encrypted, look at this, flash drive, and the theft of encrypted laptop computer. So as Syntel, we try to talk to our customers, which are really small to medium-sized organizations. We try to talk to our customers about the fact that flash drives and unencrypted laptops are absolutely unacceptable. The first part of that is the unencrypted flash drive. Why are you storing information on flash drives? And if you have to, are you taking the proper, steps to make sure that data is destroyed? And then unencrypted laptops, just unreasonable today, right? So New York, based on what took place and based on what they were seeing as trends and the lackadaisical approach that small to medium-sized businesses were actually taking in protecting information, decided to protect their citizens, protect their residents, if you will. And they started with something called the cybersecurity regulation. So if you're working with the New York State government in the financial side, the Department of Financial Services puts a cybersecurity requirement on you and says, hey, protect data. They then went further, New York State went further and created then the Stop Hacks and Improve Electronic Data Security, SHIELD. They created the SHIELD Act. In between, the DFS cybersecurity standard and what ultimately will happen, which is a new Personal Privacy Act, they created this SHIELD Act. So this is a I don't want to say a stopgap measure, but, and you'll see as we go around it, go through it, you'll see that it doesn't take everything into account. It actually extends the cybersecurity regulation that came out of the executive branch, if you will, of New York State. This actually puts legislation in place, a law. Ultimately, what New York State wants to do is have a new Privacy Protection Act for consumers. So that's the third piece. So we're actually going to see three components come together for New York State. Again, the cybersecurity regulation, the SHIELD Act, which we're going to talk about, and then We may be back on a webinar sometime next year around this, maybe around this same time, talking about this new privacy protection regulation, or actually, I'm sorry, law that they're putting together, this act they're putting together. You can track that, by the way, at New York. They do a great job of putting out information regarding this. You can check this out at their Senate, the New York State Senate's website. Stop hacks and improve electronic data security. I've been saying that for a long time. Maybe I should have coined the term shield. Let's get into this a little bit. See if there we go. What's the knowledge target? What are we trying to get out of this? Well, I want to really have you understand what the SHIELD is, what the SHIELD Act is, and what it's not, and then talk about how do you handle breaches and how do you comply with the law. So, who does the SHIELD Act apply to? This is very important, very important. If you haven't heard this before, it applies to every organization. For profit, not for profit, doesn't matter. It applies to every organization who actually stores information related to PII for New York State residents. So if you have New York State residents as employees, maybe as contractors, if you have New York State residents as purchasers or consumers of your services and products, and you're keeping any of their private or personal information, you are subject to the SHIELD Act. Doesn't matter the type of organization. Doesn't matter if you are actually an organization in New York State. You can be in Maryland like we are, and we could have employees in New York State. We're subject to the SHIELD Act. If they have a primary residence in New York State, yeah, well, Claude, they have a summer home in Florida. Yeah, it doesn't matter. If they have a primary residence in New York State, then you are subject to the SHIELD Act when it comes to their information, their personal and private information. So this goes beyond consumers. This is now going to directly impact HR because it's employee-based. You got social security numbers of employees, you're subject to this. Got to protect that. You have their home address, you got to protect that. This also goes to legal, right? Because legal may have contractors, 1099s, and their information. Now you got to protect that. So this brings in not just consumer information and protection, but also employee and contractor and any other entity that would have private and personal information that you might collect and store. If that entity, if that information is being gathered from a New York State resident or entity, if you will, then guess what? You fall under the SHIELD Act. So any business that stores private information of a New York resident, private information just at a high level is defined as name of that resident or social security number that's coupled with a driver's license number, for example, credit or debit card information, whether you have the CVV on the back of that or not. If it's credit card information, and I could use that credit card information to actually make a purchase. And some sites, some websites, you don't put in that CVV. You don't put in that special code or passcode or whatever you might want to call it. Some you just need to put the credit card in. I know when I go to the store and I just swipe, right? If I swipe, then they don't ask me for that CVV. They don't ask me for that code. So if someone can take your credit card information and create one of these plastic cards, magnetic strips or whatever with it and just swipe, I know those are going out of style, right? Thank goodness, because they have security issues like this, where I could actually impart that information on a magnetic strip, go to the store and swipe it, then that's private information, okay? That belongs to the individual. I went to the store the other day, I tried to use my chip and the lady told me the chip reader doesn't work. I'm like, boy, I don't really want to try to buy something here because I'm concerned about that magnetic strip, that swipe. Less secure. Nevertheless, what else is considered private and personal information? Financial account numbers that could lead me to gain access, let's say, to your bank account or financial numbers that give me information about how much is in your bank account. Biometric information is now covered. This is actually a broadening of most regulations. Biometric information is now covered. Anything that I could use, if I could use that information to gain access to an account that you might have online, or use that information to gain physical access, then it's covered here. And of course, your username, email address, and a password. Again, if I can access an online system that would give me access to an account, this is considered private information. Okay, sorry. What is nothing new? What do I mean by that? What is new in this, right? But it's not really anything new, because I want to go back and point to the cybersecurity regulation, if you will, of New York State. And I want to point to other regulations and laws in states that we may not, that we may not be aware of, that have regulations, like California and their California Consumer Protection Act. So what we're talking about here is a broadening of definitions, but that's not really new, because truly these definitions were broadened elsewhere. They were already done in CCPA or in GDPR or in other local state regulations and laws. But what did New York do that was new to New York? Well, they broadened the definition of private information. Again, they bring in biometric information. This is new. We didn't see this in an earlier Privacy Act or anything else. They brought in biometric information and username and email address, and they said when this stuff is used in combination that could be used to gain access to someone's online account, we have to consider that private information. So your username or email address, because a lot of times you log into a website using your email address, right? Not a separate username. To gain access to that site, that online area, you have to put in a password perhaps, or answer some security questions. So when you couple that username or email address with a password or security questions, got to consider that private information. If you use your fingerprint or finger scan to gain access, and that information that's stored using algorithms, if I can get that hash of your biometric information and couple that with something else like a username or username or email address, and that gives me access, then that biometric information is private information. An account number or credit card number, even without that security code, as we just mentioned, or even without that security code or access code or password, is now considered private information, because again, there are some sites and there are places I can go and just use your credit card number and expiration date to charge against your account. What else? Well, they broadened the definition of the word breach to include unauthorized access of computerized data that compromises the security, which I think they're now going to get redundant because security means this, but security, confidentiality, or integrity of personal information. To be honest with you, integrity wasn't always part of the definition, by the way. But I'm glad that they put it here now as well, because one of the things that we're seeing with a lot of the consumer-based acts and regulations is the fact that I have the right to know what you're holding, what private information you're holding, and whether that private information is accurate or not. Okay, so that's where it comes into integrity. Who has the right to change that information? Who has the right to validate its accuracy? The other part of breach that becomes important is that not only is it a compromise in security, confidentiality, and integrity, it provides sample indicators of access, meaning I'm showing you that I know that this has been accessed by someone who's not authorized. Previously, a breach was defined only as unauthorized acquisition of computerized data. I don't have to acquire it to read it, to know it, right? I didn't have to steal it. Maybe if I just viewed it, and that's how this is being broadened, I'm just viewing it on your site or through your, through your database. Okay. Now, and that can also mean someone internally, by the way, who's not supposed to see this information or change it. Someone internally could do that. And we don't know what they've done with that information. So therefore, that is now defined as a breach, to be honest with you. Now, just because you have a breach does not mean that it's been exploited, right? Let's keep that in mind as we go through this. What else? What else is new, or really nothing new to be actual? It is that what New York has done is saying, look, it doesn't matter if you are a business in the New York in the state. It doesn't matter if you're a registered business in the state. All businesses are now subject to this, whether they are operating within the state or across the U.S. or really across the globe. We're going to go after you if you breach any of the information, private information, PII of a New York state resident. Yeah, that's nothing new. I'm going to tell you why. Again, the California Consumer Privacy Act is saying the same thing. It doesn't matter whether you're a business in California. If you have California resident information and you breach that, then we're going to come after you as the state of California. So this is not really anything new. It's new to New York State, but it's not really anything new. And you should know that. And what is GDPR, right? The European Union saying it doesn't matter if you are a company, organization in the European Union. If you hold European Union citizen private data, PII, then you are subject to these protections that they've outlined, and you're subject to fines that the European Union might levy against you for the breach of such information. And that's funny because, or I guess it's not really funny, I guess that's not the right term. That's interesting and concerning because they're saying European Union citizen. Well, there could be European Union citizens residing in the US, and you're still subject to GDPR if you have their information. They could live here in the US but be a European Union citizen. They're protecting their citizens, not just based on where they live. So this is nothing new, and it should be understood that way, that all the states, I think, will eventually go to this and say that it doesn't matter whether you're operating directly in our state or not. If you have our state resident information, private information, or PII, look, you better protect it or we're going to come after you, okay? And I think it will get to the point, hopefully, that we actually see some type of federal action when it comes to protecting the U.S. citizens when it comes to private information and PII. So what are the goals for the SHIELD Act? Well, the whole idea for New York State is to say, can you please, just please protect our residents' information? Just take some, basic precautions. They're not looking for the most mature cybersecurity program for a small business or medium-sized business. They're not looking for you to have, billions of dollars of controls or millions of dollars of controls or even hundreds of thousands of dollars of controls. It should be commensurate with your organization and the information you have and you gather and the size of the organization and of course, ultimately, truly the risks, right, that your association has. They're not looking for overly mature, or if that's a term, but they're looking for something where you've taken at least kind of the bare minimum to some degree to protect this information. You've done some level of due diligence and you said, we can address this way, or we're going to protect this way. That's what they're after. So they're looking for improvements in overall cybersecurity, improvements in keeping information confidential, or making sure that it's not disclosed, information is not disclosed to those that don't need access, to those that are unauthorized, making sure the accuracy of information is there, and making sure that that information is available when you need it, where you need it, when the consumer needs it and wants to know what you have on file for them. Another goal of the SHIELD Act is data privacy protection, period, right? Yeah, cybersecurity as a whole directly impacts data privacy protection. Think of it as a subset, right? A lot of times in the past, when we talked about data privacy, data protection, we'd say it was a subset of cybersecurity, highly focused on confidentiality, maybe a little integrity. But cybersecurity covers all three: CIA, confidentiality, integrity, and availability. Data privacy, again, we're saying, hey, keep the data confidential and keep it accurate. We're really focused on that. And now we're going to the additional extent saying, okay, where are all the instances of this information? Where are all the instances that you're keeping for availability? Are they on backup tapes? Do we still use tapes? Okay. Are they in different areas on the cloud? And when I want you to correct this information, I need you to correct it everywhere. When I want to know what you're holding about me as a New York resident, or really California, who has that ability, that gives the ability for the consumer to know what you're holding about them, the information, I need you to tell me all that you're holding in the different instances that you might have throughout your enterprise. And most of all, if you have different instances of my information out there for backup purposes, are you keeping it confidential? So data privacy has been expanded really more to that cybersecurity. But if we just talk about data privacy protection, they want you to increase the ability for you to discern whether that person, that entity who's accessing or attempting to access that information, is truly who they are. So they're talking about, hey, data privacy protection requires authentication. Before you can access the information on that system, I need to prove you are who you say you are and that you're authorized. So authentication now, through the goal of SHIELD Act, is to say authentication should take on the form of two-factor or multi-factor authentication. Give me two things that prove you are who you say you are. At least two. This could be, where I provide a password and it sends me an access code. Pretty simple. Or even more sophisticated means, if you can afford that or feel your customers are comfortable with that. Authorization. They want proof that you are using something called least privilege, that once someone is authenticated, yep, I'm an authorized user as well. Are you just giving them enough privileges to do their job? Or are you just giving them the keys to the kingdom? We're going to give you like administrative control. You can see everything, you can do everything, and you can change, how this stuff is being replicated. You just do whatever you want. Now, they want to make sure through authorization, if you're actually authorized, you're authorized to do the bare minimum. If you only need to read this data, that's all you get. If you do need to modify this data, then we want to make sure that you're kind of certified to change this information. And there's a process for changing the information. And then finally, with data privacy protection, when it comes to access controls, they want to know that you have some type of auditing in place. If somebody were to change something, we know when they changed it, who changed it, so that we could always go back and say, we know this person had access. And even attempts at access. Let's say I authenticate, I try to access the information, although I'm not authorized, and it denies me access, there should be some record that I attempted to access this information. And finally, with data privacy protection, which goes beyond cybersecurity, there's breach notification. There's breach notification. So as part of the privacy protection, if the information is exposed to someone who is unauthorized, there is a requirement of the SHIELD Act in most, because this is nothing new, there are requirements that you notify someone of the breach. Now, the differences are, who do you notify? Who do you notify? So you'll see here in SHIELD Act, it's interesting who you notify and who holds you accountable. So, breach notification requirements specific to the SHIELD Act. If you believe there's been a breach, you must document that information and then analyze it. This might be out of order. You could say analyze and document, either way. But you need to document, oh, I believe there was a breach. Here's why I believe there was a breach. So there's justification, okay? And I'm going to keep that documentation for up to 5 years in case anybody ever needs to see it. But I'm also going to analyze, okay? I believe there was disclosure as a result of misuse, and I'm going to analyze what I think happened. The bottom line is, according to the SHIELD Act, if it's more than 500 residents, this must be reported to the New York State Attorney General within 10 days, okay? If it's 499 residents, then it doesn't have to be reported, okay? It doesn't have to be reported. Now, I'm gonna tell you, at a good measure, you should report that, right? But 499 residents. Now, when I say that it's within 10 days, it's of 10 days that you reach that number and you recognize there's been a breach. So as soon as there could have been a breach back in October, but I'm just realizing it now. I'm doing my analysis. I'm up to 499. I realize there's 500 residents or more at this point. I have 10 days to report that to the Attorney General. 10 days to report that, okay? This is a little different than other, consumer protection acts and other regulations, okay? This is a little different. It isn't saying that I need to notify the citizens. See, once I notice, not directly, but once I notice there's a breach out of good measure and other acts and other regulations, I should perhaps notify the citizens. That would be out of good measure. Of course, businesses don't do that. They don't want to drive some type of, concern with customers if there might have been a breach, but that doesn't mean there's going to be truly misuse, okay? Some companies are that way, okay? And I understand it's about a risk, right? You got to make that determination. So recognize no private citizen action under this act. And again, I am talking about this act. There could be other privacy acts or regulations at play that even under 500 residents, you need to notify folks. That's not what this SHIELD Act says. So you may fall subject, let's say you are a business in Maryland or something like that. If there's been a breach, there may be Maryland regulation, Maryland laws that you have to notify folks, even if they're outside of Maryland, okay? So this is only the SHIELD Act. With the SHIELD Act, there is no private citizen action. No private citizen is allowed through this act to sue you, let's say, okay? That's not what this is built for. It's actually the Attorney General that will fine you. And that fine can be up to that was like 10,000, sorry for that typo, $100,000 if you report on yourself within that period of time, okay? It's about $20 to $40 per resident of breach, okay? $20 to $40, okay? $20 if you self-report it, you did so within a timely fashion. They say, okay, yeah, we got to fine you. It can be up to about $100,000. If you did not declare this breach, document and inform the New York State Attorney General within that 10 days for over 500 residents, you didn't do that, then that doubles or more the actual state fine. So it could be up to $250,000. That's when you haven't done your reporting correctly and in a timely manner, okay? No private citizen action is if you will, given as a power, if you will, through this act, okay? This is all going to be a state fine. So let's talk about compliance then. Compliance, again, nothing new. How do you comply with most of these consumer protection acts? How do you meet the New York DFS, Cybersecurity Regulation, Department of Financial Services? That's what DFS stands for. How do I meet these? With some basic things. Develop, implement, and maintain reasonable safeguards to protect the security, confidentiality, and integrity of private information. It's very basic. Have a cybersecurity program. That's the easy way to comply. Honestly, if you have a cybersecurity program, no matter how mature, but you're compliant. And if there's a breach, they're going to go a little easier on you because you can show evidence that you actually were trying to protect this information. New York State Department of Financial Services cybersecurity requirements. The regulation requires that you have a standard cybersecurity process that meets the above bullet, that you have a vulnerability assessment done every 6 months. You know, we're seeing this more and more. CCPA says the same thing. The California Consumer Protection Act says the same thing. You should be doing a vulnerability assessment at least every 6 months. Now we're seeing that in the SHIELD Act. I guarantee you, when Maryland comes out with theirs, and when South Carolina comes out with theirs, they're going to want to see frequent vulnerability assessments to ensure that you're understanding some aspects of where you are weak with your security program. So you got to have a vulnerability assessment at least every 6 months, according to the cybersecurity regulation of New York State. The New York State cybersecurity regulation also requires that you actually do a pen test. In the past, penetration testing was kind of, hey, based on the risk. If you don't think you have truly a high risk, you don't need to do a penetration test. Maybe you do it every 2 years, maybe you do it every 3 years. Now, New York State is saying, hey, to meet the cybersecurity regulation, you must do a pen test every year. Every year. So, if you are already compliant with the New York State Department of Financial Services, DFS, cybersecurity regulation, then you don't have to worry about the SHIELD Act, because they say if you are compliant with our cybersecurity regulation, then by default, you are compliant with SHIELD. And I hear most people hanging up now. If that's the case, they're like, hey, I'm good, because I meet that cybersecurity regulation. I have a standard cybersecurity process. I do a vulnerability assessment every 6 months, and we have a pen test yearly. So I'm good with SHIELD, and that would be absolutely true. The problem is DFS only applies to those organizations that interact with the Department of Financial Services. So if you do insurance in New York State, you do you're a broker in New York State, you are a investment advisor in New York State, that type of thing, then you are compliant. You had to have been to actually get your contract or license or whatever. You have to be compliant with the cybersecurity regulation, and therefore you're automatically compliant with the SHIELD Act. Okay, that's the way the SHIELD Act is written. If you're not interfacing or dealing with the Department of Financial Services and you're some other business, or you're outside of New York State, because the cybersecurity regulation is only for companies that are in New York State. If you're outside of New York State, you're probably not compliant with the DFS cybersecurity regulation. So what else can you do, right? How else can you measure yourself and see that you're compliant? Have a general cybersecurity program that is mapped to actual risk and show evidence of that, okay? One of the things that, Centel does is we actually look at your cybersecurity program, and we can assess it, and we can provide you with a certificate that says, hey, it's been assessed. We can create, like in the government, what a POAM is, right? Which is a list of those areas where we believe you're deficient, and give you kind of a suggested way of going about addressing those deficiencies. But the fact is, you get a certificate saying, I've been assessed, and these are the things that, in the summary document that they found. It's okay to have findings. It's okay to have findings. It's okay to find deficiencies. But at the end of the day, that's the government wants to know, hey, do you have a program, and are you working to get better? No cybersecurity program is perfect. I don't care who you are. But are you working to get better? That's what they want to know, okay? And the fact is, you should be working to get better. Lastly, adherence to a major consumer protection standards can help you be compliant with the SHIELD Act. Adherence to major consumer, the key word there is consumer protection standards. The only issue with this is, if you are compliant with, let's say, CCPA in California, California Consumer Privacy Act, or if you are compliant with GDPR coming out of Europe, those are consumer protection standards. And remember, the SHIELD Act goes beyond consumers. It includes your employees. It can include your 1099 contractors. So adherence to a major consumer protection standard may not be enough, but it's a great start. It's like getting 75% there. If you have, you know, a standard approach to consumer protection. So how do you comply? Last slide. How do you comply? Designate an owner for the data security program. First of all, someone has to be responsible for your cybersecurity program. If you're a small, medium-sized business, someone has to be the go-to owner of the data security program, or broader than that, your cybersecurity program. And make sure that whoever's in charge of that cybersecurity program, they understand data privacy protection, and they graft that in to their processes. They graft that in to the overall cybersecurity program. If you are an organization that is capable of having separation between compliance, where you get your data privacy protection stuff, and cybersecurity, that's fine. Just make sure you have someone designated as the data protection person, right? That works with cybersecurity, because they shouldn't be siloed. There shouldn't be the creation of policies about protecting data coming out of cybersecurity, separate, distinct, and done by, you know, outside of data privacy protection, and they go create their own. That's not the way it should be done. It should be, hey, let's come to the table, let's come up with a policy and a set of procedures that covers both cybersecurity and data protection. Train and manage employees in protection practices and procedures. Yeah, it's not good enough to have a policy or even have procedures if no one's following them. And no one can follow something that they don't know about, right? So you need to make sure that it's communicated to employees that cybersecurity and data privacy protection is extremely important. And we're going to take time to train you on the right practices. Get them in the mindset, and then make sure employees are observing those practices and procedures. Assess the internal and external risks and understand what types of controls can address those risks. Evaluate service providers and bind them contractually. If you are using trusted partners, vendors, whatever, and you are providing PII of consumers or your of employees or 1099 contractors, if these service providers are getting copies of this information for whatever reason, whatever purpose, then you need to ensure they are bound contractually to protecting that information to the same level you would, because it's your data, you gave it to them. Now they should be bound to protect it just as you would, because that's what the consumer's expecting. They're not expecting you just to give away their information and not have it protected the same way. That's what your employees are expecting. They're not expecting you to release their records to someone else, a third party, a cloud service provider that's going to, you know, put those records in the cloud and not have some real protection around it. They're expecting you to make sure that whatever that service provider is, maybe it's a SaaS, software as a service, maybe it's a cloud platform or infrastructure, a cloud-based, whatever it is, maybe it's a vendor, whomever it is, they're expecting that they're going to uphold the same level of security that that you would. Don't collect private information without cause. If I don't need to know, if the company doesn't need that information in order to do what it does, to provide its services, to create products or whatever, then don't collect that information. It's just another risk. Having that information just kind of collected and then stored somewhere and not really being used, that is dangerous. That is absolutely dangerous. And when you collect this information, be, you know, really be knowledgeable of how you're collecting it. Again, is it being transferred from a vendor? Is it being transferred? Is someone filling out a form online? Is it being put on a USB drive? How is the information actually being transferred? And is that a secure means of transferring that information? And then ultimately, like USB drives, laptops, things like that, when that private information was stored on that media, how do we reasonably destroy it? Okay. How, you know, do I need to shred everything, Claude? Do I need to zeroize, which means to overwrite it multiple times? What do I do to destroy it? By the way, most of these regulations don't really give you the right answer to that. They just say that information needs to be destroyed. You need to determine what is the best practice. I mean, but if you think about HIPAA, it kind of gives you saying, hey, this information needs to be destroyed and here's some proper ways to do it. There's some guidance coming out from the government about how to, just in general, destroy confidential information that's in electronic form. You should know what those are and make a good determination. Destroying data is not throwing it in the trash, not throwing the USB drive just in the trash and saying, it's been destroyed. No, it's been discarded. If you're like some of the guys I work with, one of the guys that might even be on the phone, one of our pen testers, he might go through your trash and do that dumpster diving stuff and get that USB drive, get that old floppy disk that had information on it. That's right, I did say floppy disk. It's true. I still have a few of those around here. They're not really floppy. I have the 3.5s, right, which were kind of solid. I don't know why they call them floppy disks, because those were harder. Anyway, securely destroy private information, whatever that looks like, but that has to be done. If a consumer comes to you like under CCPA and says, what information do you hold for me? And you tell them and they say, nah, you know what? I don't want to actually do business with you. I need you to destroy that information. Please get rid of all of my information. You have to know what destruction looks like. So how do I comply? Someone's got to own the program. Employees need to know about the program and what a proper practice is. You need to make sure whatever controls, tools, mechanisms you are using for protecting information, how folks authenticate to gain access to that information, how how we audit their attempts at access. You need to make sure that it directly maps to the risks of that information being exposed. We need to make sure that service providers are bound contractually to providing the same levels, or if not better, protection for the information I provide them about, residents of New York State, okay, that I collected and that I store. And I need to make sure I'm not collecting unnecessary information. That just gives me a greater level of risk and possible exposure. And lastly, I need to make sure that I have a formal process that is understood by employees about disposal and ultimate destruction of such information. Okay. So, in summary, the SHIELD Act is really nothing new, because guess what? If you were doing business with California residents, consumers, right? Whether they buy something from you, whether they download something from you, if you're collecting their PII or private information, guess what? This is not new to you, because you should have been implementing parts of this on how to comply. Just because you're subject to CCPA, you should already been doing that. The fact is, as a small business, medium-sized business, this is nothing new, because guess what? You should have a cybersecurity program. You really should. And if you don't, we can help you with that, okay? And we cater to small and medium-sized businesses, so it won't break the bank. But at the end of the day, you should have a cybersecurity program. So this is nothing new. If you have a cybersecurity program, again, you're already then complying for the most part with the SHIELD Act. So there's nothing new that the SHIELD Act is asking you to do to be compliant. There's nothing new that is defined that you shouldn't really already know about and be addressing. So it's nothing really new to this. Okay. If there are any questions, I'm happy to answer those questions. You can open up your mic and ask the question now, or you can reach us at cyntell.com. That's CYNTELL.com. I think we'll follow up with the survey as well. If you have questions, you can indicate that on the survey or give us feedback on the usefulness of this webinar, and even make suggestions about future webinars. I'd love to, I'm a teacher at heart, so I love to be able to help small to medium-sized businesses understand and navigate both cybersecurity as well as compliance. So I'm available to you. If you have questions, my email address is there as well. You can send them directly to me at cwilliams@syntel.com. You can reach me and connect with me on LinkedIn. I'm Claude LW. Again, if there's something that you liked about this, please give us that feedback. If there's something that we can do better, we'd like that feedback as well. And we'd love for you to go through LinkedIn and like our Syntel page so that we can keep you up to date on future webinars and future services that we're providing that may be of use to you. We're not into spamming, but we are into informing. So with that being said, thank you very much for your time and attention. I hope you found it worthwhile. If there's any questions with the last 5 minutes here, feel free to open up your mics and ask those. Otherwise, when the last person logs off, we will close down the session. Thank you so much.